It's my pleasure. It's really a pleasure to host this online meeting. And my name is Jianhui Wu. I'm a researcher in Institute of European American Studies and a colleague for Serena. And in this talk, we are very honored to have Karine Peschard with us. And today Karine, she's actually affiliated Geneva academic, but she works now remotely in Montreal. And today she would talk her book on seed activism. In the past few years, I came across one article written by Karine, and I Googled a bit, and I found this book would be of great interest to our Farm for Change working group. So I decided to write an email to Karine asking whether she would be willing to give a talk, and she's so kind to agree to have a talk with us. And it's also good to know the book in Chinese version is going to publish in China, and hopefully maybe we will have some chance to get into translate into traditional Chinese version. And in the past few years, as I said, Karine, she has working on biotechnologies and food and seed, especially seed sovereignty. I think it is in the past few years. That's a very important issue. And before we start, actually, we talk with Karine about the purchase of Bayer on its acquisition of Monsanto. Very important or very evil seed bank. A lot of people, they argue that. So I would just start my introduction by saying that, and I would hand the mic to Karine. I think we would be we benefit a lot. We benefit a lot from her insight on this book talk. Karine, please, the floor is yours.
Thank you very much for this introduction. Let me first share my screen. Is it working? Can you all see my screen?
Yes.
Yes? Okay, perfect. Okay. So thank you again for the introduction. Thank you also for the invitation to present my book today. As was mentioned, the book came out in 2022, so a couple of years ago. But a Chinese simplified edition should be coming out anytime now. And on this first slide, I've put the Chinese simplified title of the book, which, according to DeepL, translates in English as Monsanto's Battle Over GMOs. Is that right? Yeah. So my background is in anthropology, and I've had a long-term interest in issues surrounding intellectual property and social justice. So about 20 years ago now, I started looking at issues around patents on drugs and access to HIV treatment in the Global South, which was a big issue at the time. And I ended up drifting towards researching a similar set of issues, but this time in agriculture, surrounding how intellectual property impacts farmers' seed practices. So I took the picture you see on the slide in the state of Paraná in southern Brazil back in 2004. At the time, I was doing an internship with a Brazilian non-governmental organization called Terra de Direitos, so it means land of rights, to learn about agrarian issues in Brazil in preparation for my PhD. And as part of the internship, I took part in this event. So what you see is the annual land pilgrimage organized by the Pastoral Land Commission of the Catholic Church. And the theme that year was, I believe in seeds, God's promised our heritage. And that day, and I described this in more detail in the opening pages of the book, farmers bound by chains and bowed under the weight of heavy bags of seeds with the logos of the main seed companies at the time, marched before the silent crowd and then got rid of their chains and burdens and set them on fire. So it was a very powerful enactment. And just a parenthesis here to say that I don't know if you're able to read the name of the company's logos at the back of the picture, but there's BASF, Monsanto, DuPont, Bayer, and AstraZeneca. And although there has been a tremendous amount of consolidation in the global seed industry in the last couple of decades, these companies are today among the top 4 companies that control 60% of the global seed market. So Bayer and BASF are still among the top 4. Corteva took over DuPont, and Syngenta took over AstraZeneca and was then acquired by ChemChina. And this dispossession was then followed by a day-long celebration of harvest and seed, which you can see on the next slide. Now, fast forward 10 years, I was still researching these issues, now no longer only in Brazil, but also in India. And I started noticing that there were legal challenges being filed in the courts involving biotech patents and royalties. And coming from Canada, where we had the famous patent infringement lawsuit opposing canola farmer Percy Schmeiser to Monsanto that went all the way to the Supreme Court, these cases really caught my attention. I became curious to find out how these court cases would be dealt with by the courts, given that compared to the US and Canada, Brazil and India have different legislation, they have different legal cultures, and of course, they also have different agricultural systems and practices. So for one thing, for example, seed saving is much more widespread in these countries, not only among small farmers, but also among some large producers, for example, soybean producers in Brazil. And also the idea of patents on seeds is much more controversial. So the book is entitled Seed Activism, Patent Politics and Litigation in the Global South, and it is a comparative legal ethnography of court challenges to the private intellectual property regimes that were implemented for biotech crops in Brazil and India. The book is the outcome of a larger research project on legal activism around plant genetic resources that Shalini Randeria and I conducted. It was funded by the Swiss National Science Foundation and based at the Graduate Institute in Geneva. So the research itself took place between 2015 and 2019, and the book came out in 2022. Now, it's tricky to present a book in 45 minutes or so, and I've been debating presenting only part of it, for example, doing a more in-depth presentation of one of the case studies. But I decided against it because the crux of the books is in the comparative analysis. And for that to make sense, you need to know about the case studies. So what I'll do is I'll just very briefly outline the case studies so you have some background. But obviously, I cannot go into the details of each of these case studies. For that, you'll have to read the book. And then I want to spend some time presenting some of the main findings and conclusions. Okay, so let me first tell you a quick anecdote that I think is very telling of the kind of issues surrounding IP regimes for biotech crops that are at the very center of the book. In 2015, I was living in India at the time, just starting to do research for this project. And the Times of India broke the story that Monsanto had never held a patent on first generation BT cotton. Now, this is 15 years after the introduction of BT cotton in India. And when I read this, I was perplexed. How could it be that the vast majority of people, including leading activists, were not aware that there was no Indian patent on BT cotton? So here's the story. According to the journalist from the Times of India, a farm activist who filed a right to information request about Monsanto's patent rights received contradicting answers from different government bodies. On the one hand, the Central Institute of Cotton Research, the CICR, responded that Monsanto's BT gene had never been patented in India. But on the other hand, the Ministry of the Environment said that the Bt cotton developed by CICR using that same gene could not be put on the market because it would infringe on Monsanto's patent. So did Monsanto have a patent or not? It turns out that the CICR was right. Monsanto had never applied for a patent on first generation Bt cotton in India. And I'll come back to this story later in the talk. But this controversy, it became known as the Bt cotton trade fee dispute, but trade fee is the expression used in India for royalties. It was not initially part of the project, but when it erupted into a full-blown controversy in late 2015, its relevance and the parallels with the Roundup Ready soybean litigation in Brazil were too good to be ignored. Okay, so the case studies. The first one is a class action lawsuit against Monsanto's royalties on Roundup Ready soybean in Brazil. As you may know, these soybeans are genetically engineered to resist direct applications of Monsanto's glyphosate-based Roundup herbicide. Now, moving to India, the second case study is the legal dispute I just mentioned among Monsanto, the Indian government, Indian seed companies, and farmers concerning royalties and seed prices for Bt cotton. And finally, also in India, the third case study is a public interest lawsuit against the international public-private partnership that developed Bt brinjal. And brinjal is the term used in India for eggplant. So this is Bt eggplant. Both Bt brinjal and Bt cotton contain Monsanto's Bt gene for pest resistance. Now, the first two case studies have a lot in common because they both involve the way in which companies charge royalties on biotech crops. The third case study is slightly different. For one thing, Bt eggplant has not been commercialized in India. There has been a national moratorium in place since 2010. And also, this lawsuit involves accusations of biopiracy in the development of Bt brinjal. Now, as you may have noticed, these three case studies have something in common, which is that they all involve Monsanto, which has since been acquired by Bayer, as we mentioned, in 2018. Now, I have to say that the project was not meant to be about Monsanto, but this is not a coincidence either, because Monsanto has been the company most aggressively pursuing its IP rights worldwide, including, as we know, by hiring private detectives and by suing farmers in the US and Canada. And in fact, not only pursuing, but also designing new private IP regimes, which are at the center of the lawsuits that I'm discussing in the book. Okay, so the question I set out to answer in the book concerned the role of corporations, states, and litigants in the implementation and contestation of IP regimes in agriculture. So first, what legal tactics have biotech corporations developed to assert IP rights in countries with stronger farmers' rights legislation and more limited IP protection? Second, what has been the role of the state in the implementation of these IP regimes for biotech crops? And third, how are biotech patents and royalty collection system contested in the courts? By whom? On what grounds? And finally, and importantly, what have these lawsuits achieved both in the courts and beyond the courts? Okay, so now moving to the case studies, I will start with the case of Roundup Ready soybean in Brazil. So this case, some of you may have heard of it. There was some international coverage at the time. It's a class action lawsuit that was filed by a local farmers union from the southern state of Rio Grande do Sul back in 2009. This farmers union represents large soybean producers, but the State Federation of Agricultural Workers, which represents family farmers, so small farmers, joined the action early on. Now, to understand this court case, I need to first very briefly explain the royalty collection system that was implemented by Monsanto in Brazil, which was unique worldwide at the time. So, in order to prevent farmers from saving seeds for replanting, which is very easy with soybean because it's not a hybrid crop, Monsanto introduced a system in which it charged royalties on harvested soybean when a farmer could not prove that they had bought certified seeds at the beginning of the season. Now, this is a major change because what it means in practice is that Monsanto's property rights extend to a farmer's harvest, right? The conventional practice in the plant breeding industry is to charge royalties on the sale of seeds, not on the harvest that is produced using these seeds. Now, from Monsanto's perspective, this was a very shrewd system because it effectively did away with farmers' rights to save seeds for replanting in a context where suing farmers was not an option, both for practical reasons, but also for political reasons. Now, in the class action lawsuit, farmers argued that charging royalties on harvested soybeans violated the right to freely save seeds for replanting, a right guaranteed to them under Brazilian legislation. So in 2012, farmers won in the first instance, so in the lower court, in what may be, to my knowledge, the first court victory against Monsanto in a case involving intellectual property. In his decision, the judge ruled that farmers have the right to save seeds for replanting without paying royalties, that small farmers have the right to also exchange or give away seeds among themselves, and that Monsanto can charge royalties on the licensing of its technology to seed producers and on the sale of seeds to farmers, but not on harvested soybeans. Now, Monsanto, of course, appealed and won the appeal. The Farmers Union, in turn, appealed to the Superior Court of Justice that also ruled in favor of Monsanto in 2019. Now, the court's interpretation was very similar to earlier decisions by the US and Canadian Supreme Courts, and it was that farmers' right to save seeds for replanting does not extend to plants that contain patented biotech genes or traits. So that's, in a sense, the Schmeiser ruling by the Supreme Court of Canada. The Canadian Supreme Court said at the time, plants are not patentable in Canada, but the court also determined that using a plant containing the patented part constitutes infringement, in practice, rendering moot the fact that plants are not patentable. Now, moving to India, the second case study is the dispute over the price of seeds and the rates of royalties for BT cotton. This dispute involves Monsanto, the Indian seed companies that produce BT cotton seeds on behalf of Monsanto, the Indian government, and farmers' organizations. Now, the way it works in India for BT cotton is that Monsanto entered into sub-licensing agreements with Indian seed companies so that they produced cotton seeds containing Monsanto's BT gene for the Indian market, because Monsanto does not have the capacity nor the germplasm to do that. Now, this dispute is both about the rates of royalties that seed companies have to pay to Monsanto for the right to use the BT technology, but it also becomes about the price of seeds because the seed companies, of course, pass on the cost of royalties onto farmers. Now, this dispute had been going on in various Indian states for a decade, but following the election of the BJP, Modi's ultranationalist party, in 2014, the central government intervened in the dispute in favor of the Indian seed companies and set the maximum retail price and rates of royalties for BT cotton, in practice slashing both significantly. Again, to my knowledge, this was the first instance of a government directly intervening to set the price of royalties and seed for biotech crops, which, as you can imagine, did not go down well with Monsanto. So this move on the part of the Indian government sparked a huge legal dispute. As part of this dispute, Monsanto filed multiple lawsuits in various Indian states. One of these lawsuits was filed in the Delhi High Court against one of its sub-licensees, a major Indian seed company called Nuzividu, for breach of contract and patent infringement. And that's where it gets interesting. This lawsuit led the Delhi High Court to examine the legality of Monsanto's patents under Indian law. And in April 2018, in a decision that took everyone by surprise, including Monsanto itself, the Delhi High Court ruled that BT cotton seeds were not patentable in India, in effect revoking Monsanto's patent. Now, this is a bit technical, but in essence, the judge ruled that the transfer of the BT trait to plant varieties through hybridization was an essentially biological process and therefore was not patentable under Indian law. It also ruled that the subject matter of the patent, a DNA sequence, did not qualify as a microorganism patentable under the Indian law. And I can come back to this, but the definition of what is a microorganism is one of the gray areas in the WTO TRIPS agreement. Third, the judge ruled that use of the patented invention could not be construed or interpreted to include use of the plants and their offsprings, both of which are explicitly excluded from patentability under Indian law. So this is in direct opposition to the interpretation in the Schmeiser case, right? And finally, the judge also pointed out that in contrast to other countries like Canada and the US, the Indian legislation guarantees substantive rights to farmers, and that therefore the Indian courts should not rely on court decisions abroad. Now, Monsanto appealed that decision to the Supreme Court, which sent the case back to the Delhi High Court for re-examination. Now, while the case was back before the Delhi High Court, Bayer, which had acquired Monsanto in the meantime, announced in April 2021 that it had reached a legal settlement with Nuzividu, the Indian seed company, that would put an end to all ongoing litigation. This happened while the book was already in press, so it's not, I don't discuss this in the book. Under this settlement, Monsanto and domestic seed companies agreed to fix royalties at between 5 to 20% of seed value, so the price of seed. Now, to give you a sense, it was 75% in the early years, so that's a significant reduction. Now, unfortunately, in my view, the settlement preempted the Delhi High Court and eventually the Supreme Court of India, because the case would have ended up before the Supreme Court either way, from ruling on the question of the patentability of plant-related inventions under Indian law. So this means that the question will remain a gray area in India, at least for the time being. And finally, the third case, also in India, concerns BT brinjal or BT eggplant. So as I mentioned, BT brinjal has not been commercialized in India. It is the object of a national moratorium since 2010. Now, during the public consultation that led to that decision, that led to the moratorium, a small Indian environmental NGO found that local varieties of eggplant had been used to develop BT brinjal without the authorization of national and state biodiversity authorities. Now, the State Biodiversity Board was quite responsive to the complaint by the NGO, but the National Biodiversity Authority not so much. In response to the NGO complaint, a high-ranking government official said, "Oh, you know, law is only an instrument. You know how things work in this country. There's so many laws which we don't apply." So to make a long story short, the lack of action on the part of the authorities eventually led the NGO, ESG, to file a public interest lawsuit to bring attention to the issue, not only of BT brinjal, but more broadly of the lack of implementation of the Biodiversity Act. Now, who developed BT brinjal? So BT brinjal was developed by the Agricultural Biotechnology Support Project, ABSP, which is an international partnership of public and private institutions funded by USAID, the US Agency for International Development, and based at Cornell University in the US. So this project includes ISAAA, which is a lobby group for the GM industry, and Monsanto. And for BT brinjal in India specifically, this project also included the Indian government, various Indian government agencies, and also Indian public agricultural universities. Now, the role of the public agricultural universities in this project was to provide local varieties of eggplant in which Monsanto's BT trait would be introduced. But they did so without applying for permission from the National Biodiversity Authority and without the knowledge of the local communities who cultivate these varieties. Just to give you a sense of how unique some of these varieties are, I did some field work around one of 16 local eggplant varieties that was the object of litigation. This variety is called Matugula. It is cultivated in a very specific ecosystem on the coast of Karnataka, in between the Indian Ocean and two rivers. It has unique characteristics, and it is also at the center of a centuries-old religious celebration at the local temple. In this case, the local farmers only found that the Matugula variety had been used to develop BT brinjal when they were asked to test BT brinjal in their fields. their response was to organize and apply for geographical indication status for the Matugula variety, which they obtained in 2011. Now, the public interest litigation put pressure on the government to bring criminal proceedings against those involved in the development of vitibrincol and to suspend the patent application. In 2013, the High Court of Karnataka ruled in the criminal complaint that on the basis of primary evidence, it seemed that the developers of vitibrincol had indeed violated the Biodiversity Act by failing to seek permission to access local eggplant varieties. However, the accused obtained a stay in the Supreme Court on the criminal proceedings that has not been lifted to this day, and it's been almost 10 years now. As for the public interest litigation, it was transferred by the Karnataka High Court to the National Green Tribunal, which are tribunals that are specialized in environmental litigation. However, the NGO, ESG, challenged this decision on the grounds that there was a constitutional dimension to the case that was outside the purview of the National Green Tribunal. And finally, this was also in limbo for years until the Supreme Court finally ruled in favor of the NGO and sent the case back to the Karnataka High Court. So as a result of this decision that was quite recent, the case was restored and the public interest litigation will proceed before the courts, but this will take time. Now, in spite of all these judicial delays, the case has had a number of impacts. First, it has brought attention to the Biodiversity Act and the need to implement it. And second, it shows how difficult it is for public institutions to protect the public interest when they become involved in public-private partnership. Okay, so now that you have some background into the case studies, I'll present some of the main findings and conclusions. Okay, so as I was writing this book, I read an article in The Guardian where a financial trader was quoted as saying, "We take advantage of the gray area between what we know we cannot do and what we believe we can get away with." And when I read this, it struck me as a perfect description of Monsanto's approach to intellectual property. As a spokesperson for Monsanto Canada said back in 2001, during the patent infringement lawsuit against Percy Schmeiser, quote, "We did have a number of people waiting in the queue, so that's farmers that could be sued, but Percy Schmeiser was the first case where we attempted to find out if the patent was valid. You don't know how strong that patent really is until somebody violates it and it's upheld in a court of law." Now, to go back to the quote by the financial trader, in the area of intellectual property and biotech seeds, the gray area was indeed vast. Monsanto exploited it fully, and it is quite incredible what it was able to get away with. So I'll give you two examples based on the research. Between 2002 and 2006, Monsanto charged an extremely high rate of royalties on Bollgard 1 BT cotton, equivalent to 75% of the price of seed. So to give you a sense, royalties on conventional seeds are usually in the order of 10%. And remarkably, it did so despite the fact that it did not hold a patent in India, but that was only revealed much later. The second example in Brazil is that Monsanto continued to charge royalties on Roundup Ready soybean for 2.5 years after its patent expired, and that was only revealed as a result of the class action lawsuit. Now, there were a number of enabling factors, for lack of a better expression, that can explain this. First, for about a decade after the introduction of GM crops, there were no legal challenges to test the validity of these patents and royalty collection systems. Second, there was very little legal expertise in the area of intellectual property and agricultural biotechnology, which had only recently been introduced in both countries following the WTO TRIPS agreement. And this is a very specialized and complex field of legal practice. Third, given the hype surrounding biotech crops in the early years, there was a real fear of missing out on the technology, and Monsanto clearly capitalized on that. And finally, and relatedly, Monsanto was able to co-opt some of the government regulatory agencies as well as some private actors, for example, in the soybean complex. And I'll come back to this. So one argument I make in the book is that Monsanto devised private IP systems that essentially rendered the Indian and Brazilian legislation moot. In fact, in what amounts to a form of IP imperialism, Monsanto seems to have operated on principle that it should enjoy the same level of IP protection than it did at home, despite the fact that the Brazilian and Indian legislation differ significantly from that of the US. As Monsanto's Brazilian manager admitted frankly at the time, by virtue of the Plant Variety Protection Act, which guarantees to farmers the right to save seeds, I believe we will be operating two systems in Brazil. One in which royalties are collected after the harvest in the case of so-called illegal soy, and the other in which royalties are collected when the seeds are sold in the case of illegalized planting. Now, this statement is a rare admission on the part of Monsanto that the Brazilian legislation does guarantee the right to save seeds by replanting. But at the same time as the business manager recognizes this right, he refers to these seeds as illegal and announces a charge that will infringe upon this right. Now, I'd like to come back to the article I showed at the beginning. The most convincing explanation for this was given to me by an activist I interviewed. And she said to me, quote, There was in the early years after Monsanto's entry into India a tacit understanding that the government would recognize the corporation's IP rights granted in other jurisdictions, even in the absence of an Indian patent. Except that this is not how patent law works, right? Patents are granted on a national or at most regional basis. Now, this tacit understanding, actually the exact words used by the activist, she said there was an unwritten etiquette. This understanding meant that the government would recognize Monsanto's IP rights over Bollgard 1 Bt cotton, even though it did not have a patent in India. And according to the same activist, this stemmed in part from the government's desire to maintain good relations with the company because it saw access to the technology as being in the country's economic interest. Now, Monsanto did not apply for a patent on first generation Bt cotton that was cultivated between 2002 and 2006, but it did apply and obtained an Indian patent for second generation Bt cotton. Now, in May 2016, I met another prominent Indian activist and I asked her whether she believed Monsanto's patents were in conformity with the Indian legislation. And I was going to her that day thinking, finally, someone will have answers to my questions. And I was really taken aback by her answer. She said, to be honest, no one really knows. The problem is that these patents have never been tested in the courts, but who among us activists can afford to take on such a legal challenge? And I wanted to mention this quote because I think it really underlines the importance of these legal actions, as well as how challenging they are. And I don't need to tell you that it takes a lot of courage to go to court against a multinational like Monsanto with deep pockets and teams of lawyers. Which brings me to another argument I make in the book, which is that activism around intellectual property and biotech seed has spurred unconventional alliances. And I don't use alliance here strictly in the sense of a formal alliance, but rather more loosely in the sense that different actors taking the same side. So in Brazil, for example, small family farmers and large soybean producers and landowners have come together to challenge Monsanto in the courts. And this is very unusual in the Brazilian context where the countryside is highly polarized and these two groups usually have conflicting interests. In India, seed sovereignty activists or progressive and internationalists have found themselves on the same side as Hindu ultranationalists in the battle against Monsanto. And activists themselves are aware of these ironies. I interviewed the spokesperson of the farmers organization that is part of the RSS, ultranationalist Hindu movement, and he said to me with an amused smile that he had found himself speaking at a press conference on GM mustard organized by civil society, and that he had shared the podium with a number of well-known food sovereignty activists who would not normally have stood on the same platform with him because they hold very different political views, but that they came together on that occasion because they were all opposed to the release of GM mustards. Now, these alliances are both a strength and a weakness. They're a strength because they bring in actors who have the financial resources and also the political influence to take on a powerful multinational and undertake long and costly legal actions. So I'm thinking about large soybean producers in the case of Roundup Ready soybean, or RSS organization and Indian companies in the case of BT cotton. And clearly the fact that these actors have joined these legal disputes really gave them momentum. In India, the shift in power was captured very well, I think, in the title of this newspaper article. Seed giant Monsanto meets its match as Hindu nationalists assert power in Modi's India. As one RSS leader told a journalist, in the previous regime, we had to stand on the street to launch anti-Monsanto protests, but with this government, we can sit and talk in a room. It's because we all believe in the same agenda. Now, this organization, which represents farmers, is particularly outspoken in its criticism of Monsanto. Its vice president once said, "It is important for all of us to unite to wage a war against Monsanto." However, on a strategic level, these alliances also come with their own dilemmas. Food and seed sovereignty activists see activism around IP issues as a double-edged sword. In the case of the government regulation of BT cotton, for example, activists are obviously sympathetic to efforts to curb corporate practices that are considered exploitative and unfair, but they're also worried that capping BT cotton seed prices will make BT cotton cultivation more attractive to farmers, and they oppose BT cotton for other reasons than royalties or seed prices, including environmental reasons. Activists are also wary of lending the support to legal disputes that are driven in large part by the short-term commercial interest of different actors in the biotech economy. And I have to say, rightly so, actors such as large farmers and seed companies whose primary motivation for litigation is commercial interest can more easily be co-opted and agree to settle out of court. And indeed, this is, as we saw, this is what happened in the case of BT cotton in India, where an out-of-court settlement put an end to all ongoing litigation and preempted a ruling on the validity of Monsanto's patent. More generally, some activists feel that they cannot afford long legal processes that need considerable resources and whose outcome is uncertain. And finally, many activists hold the conviction that the only effective way to protect farmers' rights and varieties is to work at the grassroots level to keep seeds in farmers' hands instead of relying on the court system. Now, what have these lawsuits achieved in the courts? So as we saw, results in the courts have been mixed. In the Roundup Ready soybean class action, the Farmers Union won in the first instance, but then went on to lose both appeals. In the BT cotton trade fee dispute, the out-of-court settlement between Bayer Monsanto and Nuzividu put an end to all ongoing litigation. And finally, in the BT brinjal public interest litigation, there was a favorable decision in the preliminary hearing in the Karnataka High Court, but then the public interest litigation was in limbo for several years, and now the case has been restored thanks to the recent decision by the Supreme Court. But it is important to recognize the significance of some of these decisions, even if they end up being overturned, because they create precedents and open cracks in dominant legal interpretations. One thing that is striking with these cases is that the higher up in the court system, the more is at stake and the more political pressure there is. A Brazilian lawyer told me once, "No one bothers to buy a first instance judge. It's just not worth it. You've got plenty of time to reverse the decision." In the case of Roundup Ready soybean, I was in court when the judge delivered the final decision in favor of Monsanto, and he made a lengthy opening statement on the importance of soybean export for the Brazilian economy. So we knew right away where this was heading, right? And it was clear how much this kind of economic consideration had influenced the ruling. Now, when we look at litigation, it's important to also look beyond the courts. And beyond the courts, the lawsuits have had various impacts. First, they've spurred the development of IP expertise among farmers' organizations, lawyers, public servants, and judges, something that had been lacking 10 years earlier. Second, they shed light on the status of Monsanto's patent, and in some cases raised questions concerning their validity. Third, they exposed how the private IP mechanism implemented by the coercion for the collection of royalties subverted the domestic legislation on the protection of plant varieties and farmers' rights. And finally, they revealed how public-private partnership blurred the line between public research and commercial exploitation and between public and private interests. So in the conclusion, the book conclusion, I make 4 broader arguments concerning these lawsuits. First, I argue that these legal challenges aimed to redefine the relationship between public and private orderings. So as we've seen, corporations have used IP instruments to bypass public laws. But for example, in the case of Roundup Ready soybean, farmers have argued that private commercial contracts should not be allowed to override constitutional rights. Second, these lawsuits have sought to revert the trend toward the strengthening of property rights over plants and to establish the right to save seeds as a fundamental right. Third, the lawsuits have raised the issue of the conflict between patent law and plant variety protection law when it comes to biotech seeds. And finally, and more fundamentally, these lawsuits have raised the issue of the patentability of plants in the context of the country's domestic legislation. So if there are takeaways from the book, it'd be the following. We tend to see patents as technical objects and not to question them when they're in fact deeply political. And these lawsuits, I think, really reveal the political dimensions of these issues. Second, the TRIPS global IP regime that was established now 25 years ago is still far from settled. It continues to be controversial, especially in the global south, and many issues that were created by the extension of intellectual property to living forms remain unresolved. So really the key issue is the following. When does a patent become exhausted? So when, in other words, when do the exclusive rights of the patent holder end? When the object of a patent reproduces itself, right? Because patents were not initially thought of for living forms. And finally, the last takeaway is that these issues are too important, not only for farmers, but for society as a whole, to be left to patent offices and corporate lawyers. And I will end with a quote from the lawyer representing the Farmers Union in the Brazilian class action lawsuit. Since this was ongoing, I met with him several times, and one day he told me, no, we might not win this time, but one day we will win. Thank you.